I'm the one who called them for help and they locked me up and violated my rights.
You are Arthur Mukes. Mr. Mukes, you're charged with resisting arrest, facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Please.
Thank you, Your Honor. A law enforcement officer was dispatched to a disturbance call on April 19th, 2025 in Harris County, Texas. The officer observed the defendant to be outside of the residence with what appeared to be an injured hand. The defendant stated he injured his hand while punching a wall when he was in an argument with his wife. The defendant stated that he had been drinking Crown and requested medical attention to the scene. The officer attempted to make contact with the female at the residence who refused to open the door. She only stated that the defendant should not be there at the residence and that she was in fear of the defendant. The defendant advised that he would leave the location and return at a later time. Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. The officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as the officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, the officers attempted to place the defendant in custody for public intoxication. The defendant became actively resistant and pulled away from officers while being escorted to the vehicle. The defendant told the officer, quote, "I'm coming for you," multiple times as he refused transport. The assistance of 4 officers was required to place the defendant in a patrol vehicle. The officer notes that the defendant actively resisted for 7 minutes and 13 seconds.
Mr. Mukes, I'm going to find that there's probable cause to go forward. Now's not the time. I know you're itching to say something, but look, I've got a bunch of prosecutors here. I don't want you to say something that hurts your case. Stop. Resist all attempts. If you want, I can give you a lawyer today and you can give your side to the lawyer. Okay. But right now, don't. You're only hurting yourself more when you think you're helping. Don't. I'm trying to help you here, Mr. Mukes. The only condition I'm placing on you now, you're not allowed to consume alcohol. Do you understand? If I find that you're using alcohol or illegal drugs, I will put you in jail. Just don't use. Okay? Do we know if she wants to have contact with him?
Judge, the offense date was on the 19th. We have not been able to reach out with the complaining witness yet.
So let's do this. I'm going to have them reach out. I want to know if she wants to have contact with you. If she's okay with it, then I'm going to allow it. Okay? Just don't. So we're going to try to do work on our side or their side to see if they can reach out to her, see if she's okay with contact with you. So let me see.
Morales Vega?
Okay. So, hey, do you mind reaching out to the MAC for Mr. Mukes? I'm going to get you a lawyer here for you soon. I'm going to have you sign a reset with Victoria. We're going to have you take a seat in the jury box. Just look. Just don't. All I'm asking you to do, man. Okay?
I was the victim here and
I know there are two sides. Mr. Mukes.
I'm the one who called them for help and they locked me up and violated my rights.
Hey, Mr. Mukes, there will be video. We will take a look and we'll see because the evidence is going to point to whose side's correct. I don't know. I wasn't there. Stop. Don't. Please. Good morning, Mr. Ramirez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained, and the defendant's blood was drawn.
Yeah, may I respond?
Please.
Okay, first of all, Judge, the reason, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knee, he can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I mean, I was actually thinking about that as well. All you have is an odor of alcohol. There's no accident. It's just a turn. All we have is an odor of alcohol. Is there anything else? Odor alone is insufficient.
No, that he was coming from a tattoo shop and the police officer asked him, is he alcohol because of the tattoo?
Is he what?
He just had a tattoo put on. That's the odor of alcohol.
Like, come on, man.
I'm just saying. I mean, that the officer actually asked him that question.
What are they, the little alcohol that you put on your skin, you tell me that?
I don't know how it works, Judge, but I've never had a tattoo.
You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of alcoholic beverage emanating from the defendant's breath as he spoke.
Yeah.
That's
it?
all we have before we initiated the standardized post-sobriety test.
Okay, that's not enough. All right, I'm going to find no probable cause in your case, Mr. Mears. You know,
So
we have enough death on our streets now. You know, $40. One button will get you a car wherever you want to go in this life. You know what I mean?
Yes, sir.
Use it. All right, please.
Thank you.
Thanks, Frank. You are Mark Ramirez. Mr. Ramirez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Thank you, Your Honor. On April 18, 2025, in Harris County, Texas, an officer observed a motor vehicle stopped in the right lane of traffic with its hazards on. The officer approached the motor vehicle and observed the defendant to be asleep in the driver's seat. The officer parked his motor vehicle in front of the defendant's vehicle and attempted to wake the defendant up. Once the defendant was awoken, he allowed his motor vehicle to roll forward and strike the officer's vehicle. The defendant then turned the vehicle off, but failed to put it in park, leading the motor vehicle to roll backwards and strike the other officer's motor vehicle that was on scene behind the defendant's motor vehicle. Once the defendant exited the vehicle, he became uncooperative and was required to be detained by the officers. The defendant would not answer any questions and kept saying, "Oh yeah," over and over. The officer observed a strong odor of alcoholic beverage emitting from the defendant. The defendant declined to participate in standard field sobriety tests initially. Once the defendant was transferred to jail, the defendant stated that he wanted to perform the standard field sobriety tests when asked to perform them again. The defendant was read Miranda warnings and stated that he wanted to speak to the officer. The defendant then stated that he had a 12-pack of beer since he had gotten off of work. The defendant stated he did not know what time it was and what time he stopped drinking. The officer observed the defendant to have bloodshot eyes and slightly slurred speech. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The DIC was read, and the defendant consented to providing a blood sample.
Mr. Ramirez, I'm going to find that there's sufficient probable cause to go forward with the case. If you have a problem with drugs or alcohol, now is the opportunity that you're going to get to address it. If you don't, and it becomes a problem on bond, I'm going to address it for you, and I promise you're not to like the way that I do it. Do you understand?
Yes, sir.
You are not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you like crazy to ensure that you're not using. Any prior DWIs, and does he have a license, please?
Judge, I don't have any prior DWIs, and I'm checking the license right this second.
If you do not have liability insurance and a Texas driver license, you're not allowed to drive, and that is also a condition of your bond.
Judge, we have that his license is eligible.
Okay. Do you have the ability to hire a lawyer, Mr. Ramirez? Do you work? How old are you, sir? Okay. We're going to give you time to hire a lawyer, so I will have you go to Victoria, sign a reset, and then I'm going to have you take your seat in the jury box while we get your bond conditions. A, don't use. Do you understand? You're going to get called to tested. If you fail to appear, I'm going to issue a warrant for your arrest. You understand? All right.
Well, you have,
Hello, sir.
Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Thank you, Your Honor. On April 17, 2025, in Harris County, Texas, officers were dispatched to an assault call. Officers arrived and spoke with the complaining witness, who stated her and the defendant are neighbors. The complaining witness stated the altercation was only verbal until the complaining witness exited her apartment unit and observed the defendant approach her while calling her names. The complaining witness states that the defendant then struck her 3 times on the head with a closed fist. The complaining witness stated a witness was able to separate them. The complaining witness exited her apartment unit approximately 1 hour later, at which point the defendant approached her again while stating that when the defendant was in jail, she heard the CW was talking bad about her. The complaining witness stated that the defendant then struck her on the face and head with a closed fist 5 to 6 more times. The witness stated he observed the defendant pulling the complaining witness's hair, but did not witness any striking or punches thrown. The officer observed a light red mark on the complaining witness's cheek.
Any alcohol?
Take a closer look here.
Ms. Simmons, I'm going to find if there's sufficient probable cause to go forward with the case. I'm going to tell you now that I will do everything in my power to protect my community at all costs. I don't know what kind of resources you have here, but if you don't have anyone to pony up $5,000 to $10,000 if I revoke your bond, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
I don't want you to consume alcohol or illegal drugs, and I don't want you to have contact with the complaining witness in this case. I don't want you to go within 500 feet of where she lives or where she works. You understand?
We live right across the hall from each other.
Don't want you to go anywhere near her. I don't want her to be in fear of when she's trying to get home.
I understand.
Actions have consequences, and I don't want you to go anywhere near where she lives or where she works. You're also not going to possess any weapons as well.
Judge, after taking a closer look, it doesn't specify whether or not alcohol played a role in this event.
Do you have the ability to hire a lawyer, ma'am?
No, I don't. I need one.
Okay. I'll give you an application. We'll see whether you qualify. I need to know everything about you, how much money you have coming in, where from, cars, anything, money in the bank, and then we'll take a look to see whether you qualify.
All right, thank you.
Miranda's going to give an application. You will meet with Pritchard for your bond conditions, then we'll have you meet with someone shortly.
Okay,
Mr. Walker, you're charged with driving while intoxicated. Second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 20th, 2025, in Harris County, Texas, Law enforcement officers were dispatched to a report of erratic driving in a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour and a 65 mile per hour.
Hey, don't talk. Don't talk. Can you start from the beginning, please?
Yes, Your Honor. On April 20th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a report of erratic driving of a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour in a 65 miles per hour zone and saw the vehicle almost strike a delineator pole. The law enforcement officer initiated a traffic stop and made contact with the defendant. The law enforcement officer observed a strong odor of an alcoholic beverage, slurred speech, red glossy eyes, swaying, and unbalance from the defendant. The defendant admitted to having 2 beers prior to driving, or 2 alcoholic beverages unspecified prior to driving. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The law enforcement officer found an open container of an alcoholic beverage on the passenger side floorboard, cold to the touch. The defendant consented to breath and blew a .137 and a .127.
Mr. Walker, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your ability to drive. You are not allowed to drive. Do you understand? You will be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Because it's a second offense, I'm requiring you now to get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If I find that you do, I will put you in jail. No more PR bonds for you. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. Does he have a license? Can you run it?
Yes, Your Honor.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria where we will have you sign a reset. You will then get with pre-chop for your bond conditions, and after that, you'll be free to go. When you come back, please have a lawyer. Please.
Judge,
Oh, hold on, Vic. Let me tell Mr. Walker one more thing. Come up. I am placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. I'm sending notice to DPS in Austin so that every single officer in the state knows that if you're in a vehicle driving, that vehicle is supposed to have an interlock on it. If you're caught and you don't have one, they will take you to jail. As it stands now, as part of your bond conditions, I'm warning you not to drive for the time being. Do you understand? Look, it's not, I'm just, no response is required. I'm just telling you what the expectations are. And if you violate these conditions of bond, I will revoke the bond and I'm going to put you in jail.
I know, I'm trying to get a real good understanding. That's why I want to ask the question.
You need a lawyer. I don't want you to ask something. I don't want you to say something that hurts your case. We're going to give you time, please. All right. Good morning, Ms. Arena.
Hello, how are you today?
We took you into custody, or we have you in custody now because you are on deferred for an aggravated assault of a family member. And a motion, I'm assuming a motion, let me make sure. Yeah, it looks like a motion to revoke has been filed and you are at a bond denied status now, meaning that you're being held at no bond. So what we're going to do is we're going to do probable cause in this case here. We have to take you into custody. You will probably populate on Monday's docket for the felony court.
That's for what?
You're now charged with driving while intoxicated.
Now, see, here's the thing.
Oh, did I ask you to say anything?
No, sir.
Okay, please. You have the right to remain silent. Exercise that right. You
Yes,
may
sir.
say something that hurts your case unknowingly when you're trying to think that you're helping. Just don't.
Yes,
We're
sir.
going to do probable cause. Like I said, you have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I'm going to appoint you a lawyer after we do probable cause. You can speak to someone here momentarily. Okay. So let's just do this real quick and then. Okay.
Thank you, Your Honor. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on.
Start from the beginning, please.
Yes, sir. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on. The officer observed a male asleep behind the wheel in the driver's seat. The officer contacted the defendant and observed him to have red, glossy eyes and a strong odor of alcoholic beverage emitting from his breath and his person. The defendant initially refused to obey verbal commands to exit the vehicle. The defendant then exited the vehicle and stated that he would not allow any deputies to detain him and would not perform standard field sobriety tests. The officer took the defendant into custody. The officer notes that the ADA accepted charges under no refusal and that a specimen was not needed.
Did anyone see him drive? He's sitting at a pump, he's sleeping. I mean, the officer try to go look at camera footage to see if they see him driving at all. Does anyone have him driving?
Judge, we do have camera footage from the Exxon recording the defendant driving into the gas station on the dim summer. Yes, Judge.
All I'm asking is, do you have something that shows him driving? Okay. Mr. Rain, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well.
Yes,
You
sir.
understand? Just don't use alcohol or illegal drugs.
I completely understand.
Okay. Hold on. Does he have a valid license? Can you check, please?
Yes, Your Honor. I will check.
As long as you have a and then does he have any prior DWIs, I guess, as well?
There's no prior DWIs.
Okay. License.
And the license status should be ready for my review. Pulling up. It is. Trying to load up. It says it's eligible, Your Honor.
Great. Before you say something, let me please give you a lawyer and let me have you talk to the lawyer. And then whatever issue you may have, they can come back and talk to me. I just don't want you to say something that hurts your case in any way. I'm trying to help you, I promise.
You understand?
Just don't. So go ahead, put him back. We'll give him a lawyer, but don't send him down because are you ready for conditions? Okay, take your time. No rush. Okay. You are on bond for a tampering case and you've now picked up a burglary of a motor vehicle. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 14, 2025, in Harris County, Texas, a law enforcement officer was flagged down by the complaining witness. The complaining witness advised the officer that a male had just broken into the complaining witness's motor vehicle and drove off in a different motor vehicle. Another witness observed the defendant break into the complaining witness's motor vehicle and provided cell phone video to the police. Additionally, the complaining witness observed the defendant break into his motor vehicle and chased the defendant through the parking lot. The officer pursued the defendant on foot. The defendant was detained and positively identified by both the witness and the complaining witness. The defendant admitted to breaking the complaining witness's window.
What time of day or night was this? Or was it during the day?
It's in the daytime, it appears, Your Honor, but also, like, when you read the summary, it looks like an officer detained him on a bicycle and that he was wearing different clothes from the description of the foot pursuit, that clothes were ditched.
I don't know.
So then they did a drive-by identification of the suspect.
Mr. Robinson, what is the one thing I asked you not to do? The one thing I asked you not to do. Not be a danger to my city or pick up a new case. You've now picked up a very I'm going to find that there's probable cause to go forward with the case, and I'm now going to put a monitor on you so I know where you are at all times. If you get out of custody, because now I'm revoking your bond, you will go to jail. If he gets out, GPS monitor not to go within 500 feet.
He has a GPS monitor on him.
Putting him in custody. No alcohol, no drugs, no weapons, no going within 500 feet of where the complaining witness lives, work. And I'm going to tell you now, because I don't know if you're going to get out, but if you do, you endanger my city again, I'm going to go ballistic on all of your bonds. Do you understand? Goes with you.
I have
Judge, I have no reason to doubt that,
Scott, just, there's no need. It's done. Every time you take off and when we revoke your bond, all you do is you're giving money to bonding companies. You just enrich bonding companies. That's all you do. I don't know if you got a lot of free money, but if so, I guess we'll stick with the conditions that we had before. Just no contact with the complaining witness, no weapons. So do you have an offer in this case now?
We do.
Okay, so we're going to set your case for trial today. You must appear for trial date, 8:30 in the morning. Don't appear at 12, not at 1, and then we'll be set. I guess May. Let's see. Today's what? May 27th, okay with you?
Judge, that's a short week. Oh, yeah. June 10th or May
What time
20th.
do we have on the 3rd, Ramona?
I'm sorry?
What about the 3rd?
Victoria's out that week.
June 10th. Is June 10th a holiday week too?
Yeah, we can make it a holiday week.
No. June 10th it is.
No, June 10th, Judge.
Everybody's a comedian.
Thank you, Judge.
Comedian.
Thank you. Thank you.
we're gonna have recite the petition.
Hi, you ready? Yes, ma'am.
I picked up Mr. Mook's case today. I'm not sure how to pronounce that, but
That's right.
yeah, I think he left already. But I was wondering if we could rehear PC.
Okay.
Oh, he did? Oh, okay. I'm sorry.
But I hope, because I had asked him to reach out to the complaining witness just to make sure that she's okay.
Okay.
Because if she,
One issue there. So because it was resisting, it's not in our system. Both contact information is not in our system. Now, when the office report comes through, it should be. Problem is we don't have that office report yet. I'm going to keep checking it. I can try to run through RMS.
I mean, until I know, yeah, that's Mr. Mukes right there. So until I know, I'm going to order no contact because I don't know, because she was scared of him there,
Uh-huh.
So,
I understand. I was wondering if I could, I'm just approaching on PC for it. Yeah, but
oh,
to rehear PC, yeah.
okay, sure. Do you mind reading it again? Please.
Officers were dispatched to a disturbance call on April the 19th of 2025. Officers observed the defendant to be outside of the residence with what appeared to be an injured hand. Defendant stated he had injured his hand while punching a wall when he was in an argument with his wife. Defendant stated he was drinking, quote, Crown, and requested medical attention to the scene. Officers attempted to make contact with a female at the residence who refused to open the door. She only stated that the defendant should not be at the residence and that she was in fear of the defendant. Defendant advised that he would leave the location and return at a later time. Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. Officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, officers attempted to place the defendant in custody for public intoxication.
Here's my problem. I didn't have a problem until that point.
Right, I understand that, Your Honor, but if the police are arresting him for public intoxication, the front door is not a public place under the statute or under case law or under the
No, it's not.
definition. It doesn't
That's
matter.
right.
It doesn't matter. It doesn't fall within the definition of a public place. Public places are where multiple people go through. They're common areas. It's not a public
He's
place.
not in his house.
It is his residence. It's
No,
his
he's
residence.
outside.
He's outside. And I would argue,
He's
Your Honor,
outside. He's not inside the house. He's
He's
outside.
right at the front door, and so
I mean,
Your Honor, I would argue, mailman go up to the front door, the letter packer goes to the front door.
I don't think under the statute it qualifies. I mean, I
show
have,
me a case that says
sure, I have the definition.
or is,
Right, I have the definition of a public place under the
I know what
Texas
the
Penal
definition of a
Code.
public place
It's
is.
like
Should-
apartments, hospitals, libraries, schools, office buildings, sidewalks, like driveways, the public road, not the front door. I mean, even the police, like, there is a reasonable expectation of privacy of going into the front door of the house. Like, it's not really considered a public place under the statute.
Show me case law, because I don't know. I mean,
I'll try, I can find.
I know I know the definition. I've seen the
Right,
definition,
yeah.
right? But show me something that says that being, near the front door is private property. So it's not.
I
Right.
mean,
Right.
at the front door. I mean, that is like, people have a reasonable expectation of privacy in their home, like,
In their home.
right.
Yes.
And at the, like, even at the very, like, front of the door. I mean,
We don't know exactly where he is.
but that's what the DIM says.
Okay.
Your Honor, what I would say, he's clearly not in the house. He's at the front door. He's threatening to kick the door down after they had just gone out on a domestic related call. And she said he appeared to be intoxicated. The defendant himself told officers that he was drinking Crown. They decided that based on the facts, he was a danger to himself, and they decided to place him in custody for public intoxication.
Mr. Mukes, come on up.
I'll turn the live stream on.
Martinez, Georgina?
Yes, sir.
Yes, sure. Yeah, no, to have, I mean, Brenda wants to, I we can't. She's all right. She's not calling. She can find out.
Right. I said, the messages get sent out, so get a photo by how you get here each day.
You know what I mean? So you let her know that if mom doesn't have to be contact with her, doesn't let her know to come in and
It's work, you can make them bond it.
Yeah, I'm not, hey, let her know we're not gonna play games. I don't care.
Mr. Marlon Simmons, Your Honor. This was a DWI PTI that went south.
It was remote.
Why for a plea?
Was tested positive for THC and alcohol, and then just picked up a charge out of Waller County for operation of a salvage vehicle on a public walkway.
Okay, so this case is 517 days old. Do you have an offer on the case?
Yes, Your Honor. This was a 12-month probation since it's been kicked out of PTI.
Okay, so you must either accept the plea bargain from the state or I'm going to set your case for trial today. So they've offered you a 12-month probation. You talk about it with Mr. D to see if that's something that you want to do, because I don't know. Is that the only offer you have?
That's the offer I've made, yes. That's the
Okay.
offer for now.
So,
He's already spoken with me, Judge.
so you let me know what you want to do.
The
If you want-
plea is ready for right up there.
Yes.
Yes, sir.
Oh, I didn't realize.
Yes, sir.
Okay.
And that's straightforward, Your Honor.
I'm going to tell you now that we've repeatedly asked you, we've repeatedly ordered you not to use. So you either don't care about the bond conditions or you got a problem. And I'm going to tell you now, we put someone in residential treatment kicking and screaming that they didn't want to go yesterday. So if you continue to test, I can modify your conditions to put you into an inpatient treatment program at a minimum of maybe 3, 6, 9 months, maybe a year and a half, depending on how well you respond to treatment. Do you understand? So, and I'm telling you now, I will test you like crazy. The first instance you use, it's not going to go well. I will issue a warrant for your arrest. We will have a hearing, and if they prove it to me, because I'm not letting you go until the act is clean. Do you understand me, Mr. Simmons? This system will not fail you. The agreement that you have worked out is 180 days in jail to be probated for 12 months. As part of the agreement, you will do a DWI education class, 2 victim impact panels. Has he done a TRAS yet?
They recommended supportive advocacy.
Was that the way?
Mm-hmm. Okay.
Let's do a new one.
Stop it.
Substance abuse treatment as required by the TRAS. No breath test refusal, meaning that if you're pulled over, an officer asks you to take a breath test, you must do it while you're on this probation. No drugs, alcohol, and a guardian interlock.
Judge, with respect to the guardian interlock, client has informed me that he does not have a vehicle at this particular time. So I will request that the board allow him to use the portable device in lieu of the guardian.
I'm okay with that, but I'm telling you now, Mr. Simmons, that you will be signing an affidavit promising you're not going to drive. I don't care what your excuse is. If Holy Mother Mary comes from and asks you for a ride from church, you drive. You can be facing an additional 6 months in jail on a contempt and a $500 fine every time you drive. Do you understand?
Sure.
Do not drive. Is it because he doesn't have a license?
He does not have a vehicle, he informed me, Judge.
Do you have a driver's license?
Sure.
Okay. We are sending notice to DPS so that every officer in the state knows if you are in a car driving, you are to have a guardian interlock, a breath test device. If you don't, you're caught driving a car. They're going to put you in jail. Don't be sneaky. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. You can never change this. The other thing, Mr. Simmons, is this now will reflect as a conviction on your record. You ever get pulled over in the future, be it 20 years from here, 30 years, you even have the faintest smell of alcohol or dope, they're going to see this DWI. It's probably not going to go well for you. Do you understand? I do plead to the offense of driving while intoxicated. Guilty and I'm guilty. I'm going to find you guilty. I'm going to send you to this agreement. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Mr. Dean.